Hello, good evening and welcome to UPfront. My name is Raymond Akwa. Now tonight, the President of the Republic of Ghana is asking the Parliament of the Republic of Ghana to pass a law, the Vigilantism Bill. This bill's real intent is if you are identified as a vigilante group, you go to jail for 25 good years. Settled, 25 good years. If you actively participate in any activity that suggests that you are in a vigilante group. In fact, the bill also names some specific groups like the invisible forces within the NPP and also the hawks within the NDC as groups which are banned from existing on the surface of this earth in this part of the world for good. But is this the panacea to the problem of party militia in this country? After the break, my guest will tell us why. You welcome back. This is UPfront. My name is Raymond Akwa. Now, let's start by speaking to a man who's been very vociferous on this particular matter. He is the minority spokesperson and ranking member on the Defense and Interior Committee of Parliament. He's a former Deputy Minister of Interior, the Honorable James Agaga. You're welcome.
Thank you, Raymond.
I hope you are doing well this evening.
I'm fine, by God's grace.
This, to many, is the boldest step ever by any president who is willing and ready to deal with this problem. Do you disagree?
Raymond, I disagree. This cannot be the boldest attempt yet to deal with the issue of vigilantism. In any case, who says it is the introduction of new legislation which is the panacea to the problem of vigilantism? I have always maintained that we are not lacking when it comes to the existence of laws to deal with political vigilantism. What we lack, what we have lacked, is the political will and courage to apply the laws and deal once and for all, deal with the issue of vigilantism once and for all. And so the president's decision to introduce a new legislation, even at a time when the report of the Commission of Inquiry that he himself set up has not yet been made known, at a time when the political parties dialogue, the interpolitical parties dialogue that he himself called for, has not even concluded with its work and come out with recommendations which ordinarily should guide the process of legislation. That is, if we all come to the consensus that legislation is the path to walk, where are the recommendations? Shouldn't we be guided by the work of the Commission of Inquiry that he himself set up under Chapter 23 of the Constitution? So you see, this attempt for me is very hasty, okay, and should not happen at this point in time. Okay, so I'm unclear in my mind. What's the thrust of your argument? Is it the timing of it? Is it the pace at which it's been introduced? And thirdly, is it that the entirety of a new bill that seeks to stop this phenomenon you and I and many in this country have actually been on as a situation very dangerous and a threat to our democracy? Raymond, I have taken a position and I've been very consistent that we have sufficient legislation in our Criminal and Other Offences Act to deal with vigilantism. For instance, I mean, there's a clear provision in, if you like, Section 202 of the Criminal and Other Offences Act, which outlaws unlawful assembly. So if a group of persons come together, assemble with the intent of committing a crime, they have already committed an offense and are punishable under the Criminal and Other Offences Act. If they so assemble and decide to use offensive weapons, in fact, they have even committed a second-degree felony and are punishable under this act. Now, if you purport to establish a security company or outfit to, as it were, perform security-related functions, you could also be held criminally culpable under the police service, private security organizations regulations, and punished under that law. So we have the gamut of legislation.
Your colleague, the ranking member on the Legal, Constitutional and Parliamentary Affairs Committee, the Honorable Yunus Afuseli, believes that existing law actually treats the phenomena properly defined as a misdemeanor, a small crime. I don't. Does it rise to the level of the attention we want to give it?
No, the issue was raised this morning.
Yeah.
But that issue clearly, I mean, the one who pointed to the fact that most of the offences that already exist, which could be invoked to deal with vigilantism, misdemeanors, was the Honorable Minister for the Interior, Mr. Ambrose Deru, who is a lawyer.
Okay.
But I don't agree with him, because if you read through the Criminal and Other Offences Act, for instance, I just pointed out the fact that if you assemble unlawfully without actually brandishing offensive weapons, that is a misdemeanor. Okay. But if you are found to be in possession of offensive weapons, you commit a second-degree felony. That position of the law can be found in Section 202. But on the other hand, if you are found in possession of arms and ammunition, you commit a first-degree felony. You see, what happened at Ayawaso involved the use of firearms. Yeah. And so those who use those firearms, if they were arrested, could have been dealt with, and their offense is a first-degree felony. And
you're of the opinion
so the argument that most of the offenses that deal with
vigilante people.
Absolutely.
Really?
Now, this bill doesn't
even... It's not pretty obvious that it involved only security members.
I don't think so. So we're in the situation where vigilantes have infiltrated the security structure. What happens?
That's yet to be established fact in the ongoing engagements with the Ayawaso West Commission.
Absolutely, and that is the more reason why we thought that this government ought to have hastened slowly, because the recommendations of the Ayawaso the Commission of Inquiry have not even been made known.
But the president has seen the recommendations. The president is convinced that this law equally ought to be put before Parliament.
Hasn't seen the recommendations, and yet we are the arm of government charged with the function of passing laws. We should be well informed. We should be well informed, Raymond, before we pass laws.
But there's a time frame for the president.
6 months.
Yes, but it's not been 6 months.
To publish or issue a statement indicating why he wouldn't publish.
That's the point.
Now, if that is the point, we all know why the Commission of Inquiry was set up in the first place. The president may have acted in good faith because he believed that this country must deal with the issue of political vigilantism once and for all. If these were the compelling reasons for the establishment of the Commission of Inquiry, the president should have no justification whatsoever to withhold the recommendations, or, if you like, the report of that commission from public view.
If what you are holding today as the bill is purely influenced by these particular recommendations from the Ayawaso West
Parliament is not privy to the recommendations.
Without the recommendations,
Parliament reserves the right to be well informed before we pass legislation. Remember that it is the sole preserve of the legislative arm of government to pass laws.
If out of the specific,
they have not told us clauses in the memorandum to the bill that
it is based on the
Ayawaso West Commission of Inquiry's views.
Based on it.
Do you know that for a fact?
But I say he might have taken his
as the legislative arm of government. We are saying that we reserve the right to know. We don't know yet. Shouldn't we be guided so that we pass laws that can stand the test of time? Listen,
let's be clear.
Listen,
Raymond, of the 10 provisions of this particular law, which of them requires some insight from the commission's work before you can actually consider any of them?
No provision requires that we take a look. But that is not even the essence of a bill. That is not the essence of a bill.
I do not understand why you, the Member of Parliament, a former Deputy Minister of Interior, mindful of the security threat in this country, and your colleagues who receive reports every single time, and this is not the first time vigilantism has been a problem in this country. Again, you also belong to a political party.
Raymond, let me stop you there. This is the first time a Commission of Inquiry has been set up to look into acts of vigilantism which marred
a single by-election. A single by-election.
Yes, it doesn't matter. It doesn't matter. But we need to be guided and informed by the recommendations of the commission. Remember that the Commission of Inquiry had the opportunity to invite experts, people who have researched extensively on the issue of political vigilantism. I mean, the likes of Dr. Kwesi Enin and the rest. They appeared before the Commission of Inquiry.
Including our very own Evans Mensah.
Absolutely. So why would you deny Parliament the opportunity of becoming privy to the recommendations so that Parliament as the People's Assembly, can be properly guided in passing a legislation of this kind.
Now you have moved from this is not a relevant law to we need something else to be able to work on it. That's a positive direction, isn't it?
So my first point, Raymond, let's not mix up the issues.
Get your point.
And that is my view.
Yeah.
That is my view, that we have sufficient legislation that could be invoked to crash political vigilantism, but we lack the political will to do so. For instance, the acts of vigilantism that occurred, that we all witnessed at Ayawaso, could be dealt with if we had the courage to effect the arrest of the perpetrators who are known to the state. But the state simply hasn't got the courage to effect the arrest. Simple. It's as simple as that. So you don't blame our inability to deal with Ayawaso on the lack of legislation. I think the president simply wants to take cover with the introduction of this bill to send a signal that he is bent on dealing with the issue of political vigilantism.
It's not obvious, yes.
It's not. What happened in the case of Ayawaso? Have we arrested the perpetrators of the violence at Ayawaso?
Commission of inquiry.
Yes.
That's seeking to put the
Remember they told us that the investigative apparatus of the state was not by any means of imagination going to be stopped.
Yes, that's true.
From conducting investigations.
Yeah.
Raymond, how many people have been invited by the police in connection with Ayawaso? How many people have been arrested?
Sorry, forgive me. You are on the Interior and Security Committee and Defense Committee of Parliament.
Zero arrests. Zero arrests. I'm asking rhetorical questions.
Yes.
Zero arrests. Which demonstrates, yes, zero arrests, which demonstrates the lack of will on the part of the state.
Really?
Absolutely. To deal with the issue of vigilantism. Do you blame this on the lack of existing laws?
Let me be clear. Were there any groupings, anybody arrested in connection with the Etiwa incident?
Etiwa incident?
Yes, the Etiwa by-election and the violence that
Yes, people were arrested.
Really?
I was at Etiwa.
Oh, okay.
I was nearly lynched at Etiwa.
You?
Yes,
too.
yes.
The
I was nearly lynched.
The ones who were being attacked.
I was nearly lynched at Etiwa.
Really?
Yes. Some arrests were made.
Yeah. And they've been put in jail. Oh,
I can't remember what happened.
Even though you were Deputy Interior.
No. I was not a politician at the time.
Of course,
Make no mistake.
Yeah.
I was not a politician at the time. I went to Etiwa as a party faithful of the NDC to monitor the elections.
We came under attack.
I didn't hold political office. Let me put it that way. I was practicing law.
Okay, I get your point.
Let me put it
but
that
you're
way.
a politician then.
Yes. But not to deviate from
I get your point.
the subject.
I'm trying to say
so my point is
I
that
expect you to admit that this is a step in the right direction.
We have sufficient legislation to deal with the issue of vigilantism. But if we all agree, that there is need for us to harmonize existing legislation, and if you like, improve, fine-tune the legislation and make the legislation more specific, why is there the need for us to treat this under a certificate of urgency?
I'll come to that point.
Why is there the need?
I'll come to that point.
In fact, and this is happening on the back of the president's own decision to set up a commission of inquiry, his own directive that the two political parties engage and voluntarily disband. And that if the political parties involved here were to refuse to engage and voluntarily disband, he would initiate legislation. That was a conditional statement.
Yes.
There has been a lot of back and forth, but in the final analysis, the political parties have decided to engage.
After how
they have started engaging.
After how long? The president gave 1 week for the NPP to reach out to the NDC. Several weeks passed. In fact, we counted down several weeks in this particular
case. That is because, Raymond, the government, the NPP, took a certain position that there was no need to involve other major stakeholders. That was what served as the drawback. But with time, they themselves came to the realization that that position was untenable. They backed down.
The president
that has now paved the way for the two parties to engage with the active involvement and mediation of the Peace Council.
The president leading the state has elevated himself above partisan politics in this case.
But is that tenable?
Really? It's not?
It's not.
Really?
Why? Is he not a product of a political party?
The father of the nation
rode on the back of the NPP to become president.
The father of the nation cannot be elevated above partisan politics.
It's practically not possible. He's a product of partisan politics.
I see.
So let nobody tickle himself and laugh that the president can detach himself from partisan party politics, because it's a product of same.
Okay, now let me get this clear. The Criminal Offences Act at 29 says in section 202, you mentioned that. The first one says, whoever takes part in an unlawful assembly shall be guilty of a misdemeanor.
Continue. Unlawful assembly, continue.
Yes, okay. So whoever takes part in an unlawful assembly armed
yes, go on.
any offensive weapon
good.
or missile
good.
shall be guilty of second-degree felony.
Felony. Go and read the section 192 on possession of explosives.
You mean the same criminal offenses?
Yes,
Act?
192.
Okay, so no, let me make this clear.
192 also says if you are found in possession of a firearm, whether you're a vigilante or a private person like you,
yes,
you are guilty of a first-degree felony. But you know the possession of firearms is something that is usually associated with vigilantes. Like we saw at Ayawaso, they clearly fired shots. Okay. They wielded powerful guns like AK-47.
But the same thing happens with land guards. They possess firearms.
Yes, yes. So they can be charged under this provision.
Yes.
Possession, which is a first-degree felony. I'm referring you to these provisions to debunk the assertion that most of the laws in existence, which could be invoked to deal with vigilantism, are misdemeanors. That is not true.
I get your point, but let me
is not true.
Read the sections that you just referenced. And
192.
Section 192 is on possession of explosive firearms and ammunition without lawful excuse.
Absolutely.
Without lawful excuse. One says, notwithstanding the provisions of any enactment, possession of any person who has in his possession custody or control without lawful excuse, the proof whereof shall be on him. Any explosive firearm or ammunition shall be guilty of first-degree felony.
Absolutely.
Provided that no prosecution shall be instituted under this section without a consent in writing of the Attorney General.
Yes, I mean, that position is clear because the prosecutorial powers of the state are vested in the Attorney General under Article 88. So all forms of prosecution are actually in the name of the Attorney General.
We will go into the law after this break. We'll take a little break now. When we come back from the break, we'll be joined by the chairman of that particular Constitutional, Legal and Parliamentary Affairs Committee of Parliament that has this evening agreed, contrary to the views of the Honourable Member of Parliament here in the studio, that they are going to consider the bill under some form of urgency. He will explain that to us after this break. Welcome back. This is UPfront. My name is Raymond Dalkwa, and today the President of the Republic of Ghana has actually asked the Attorney General, and they put before Parliament the bill on vigilantism in this country. This bill, among other things, says if you are caught engaging in that particular act, which is outlawed according to this particular bill, you will spend 25 years at maximum, 25 years in jail. This is what is currently the biggest topic in this country. My guest, and I started the conversation with the ranking member on the Defense and Interior Committee, who has had very strong views on whether or not we need a law to make this work. Now, we've been joined, as I did tell you, by the chairman of the Constitutional, Parliamentary and Legal Affairs Committee of Parliament. That chairman is Ben Abdullah Banda. Honorable, you're welcome to.
Thank you.
Yes, so we started the conversation, and I'll come back to you, Honorable Agaga. Now, we started the conversation by me seeking to find out whether this is a good move, a wonderful decision, a president who is seeking to deploy action, not just talk about the problem, but deploy action in this particular case. He disagrees. He believes that it's poor timing. In fact, even if you agree that the law ought to be put in place, he insists that until we have the report from the Ayawaso West Wagon Commission, which should inform you in the legislature on how to deal with this particular issue, it was surely not going to be a work in the right direction. I sought to tell him that there is enough evidence to suggest that the laws in this country, they treat vigilantism and these related offenses as some joke of a sort with a misdemeanor. But he sought refuge under Section 202 and 192 of the Criminal and Other Offences Act. Now, let me be clear my mind to you. From what has happened, and this is not the first time we discussed this particular issue, what does the memorandum say about the actual need for this particular bill? And what is captured in the memorandum as vigilantism in and of itself?
Thank you very much. And let me say good evening to all your viewers and your listeners as well. Yes, there is a law on everything. There is a law on almost every criminal activity. You can talk about assault, you can talk about causing harm, you can talk about murder. It's all parts, or it's all, activities that are associated with vigilantism. But vigilantism per se, in its ordinary meaning, it's not anything bad. Vigilante or vigilantism is not bad. The ordinary meaning of vigilantism is clear.
Okay.
It's not anything that connotes negativity.
Yes, I think that is why Professor Mensah Bonsu said it should be rather party militia. That's why we use party militia.
So we have used vigilantism in a negative sense.
Yeah. And
the way vigilantism, party vigilantism, is gaining ascendancy and is becoming deep-rooted in the fabric of the society, and to the extent that it's become a social phenomenon, I think that there is the need to have a specific legislation to deal with that. There is the need to have a specific legislation to deal with that.
Maybe that question matters. I get you. I mean, I want to ask this question. There should be a reason why the current law, if disabled or not complete enough to deal with the matter, should be dealt with differently. That reason should be grounded equally in law in this particular case. There should also be a reason why, when all the provisions that we have been given under the Criminal Offences Act, sections 202, 192, either be deemed inadequate or incompetent to deal with the problem. I cannot, and I think the Honorable James Agaga pointed out that some of these conduct has even been described as first-degree felony, second-degree felony, and is properly captured. Why do you think, exactly what vacuum will this vigilante law fill? Exactly what lacuna existing in our current laws will this vigilante law fill, regardless of whether we now are talking about it in a different format or not?
Vigilantism is associated with political parties. Vigilantism is associated with political parties. And by talking about vigilantism, we are also dealing with landguardism. It's all part and parcel of the bill. Yes, whether it's coming to fill a lacuna.
Yes.
The lacuna that is coming to fill, if you talk about the laws are there. But specifically speaking, vigilantism is also now becoming a criminal offense. Vigilantism is also becoming a political party activity that is being prescribed.
Now, is vigilantism in and of itself a separate activity from any of the activities that could be captured under lawful assembly?
Vigilantism, as it is being defined, I am very cautious about going into the content or the merits of the bill, because, as we all do know, it is a draft bill.
That's true.
And it is on the basis of this that the committee in its wisdom felt and thought that this bill is one that we have to seek broader and wider stakeholder engagement in order, at the end of the day, to be able to come up with a robust law regime or legal regime.
I get your point.
So what I'm saying here is that, at this point is that if we go to the interpretation section of what vigilantism is, vigilantism means
that clause 10,
the act of enforcing law and order without authority except as provided in Article 3 of the Constitution or any other enactment. That is a new criminal offense that this bill is purpose to bring into being. So vigilantism,
give me a
in
second.
its ordinary sense, in its ordinary sense is not bad, as I stated in my preliminary comment. But within the context of the law, that is the Vigilantism and Related Offences Bill, it is now a criminal offense.
Honorable, the offense referenced in this particular case, can it be dealt with by any law in this country today?
Yes, Raymond, I have reservations even with the attempted definition of vigilantism.
Okay.
And if you consider the fact that under our constitution, the chapter on fundamental rights, more specifically chapter 5,
okay,
article 19, you'd find that the freedom to associate is guaranteed. It's a guaranteed right.
Okay.
So I have been looking at the definition critically, and I've also juxtaposed this definition with the definition of unlawful assembly under section 1201
okay.
of the Criminal and Other Offences Act. Now, with the definition of unlawful assembly, what the element is that the act of bringing people together would be unlawful if there is an intent to commit a crime. So you must be able to establish, in order to succeed with the prosecution, that those who assembled intended to commit a crime.
Give me a second. Let me read section 201 so that we all understand, those who have not read.
Yeah.
It says in 1, when 3 or more persons assemble with intent to commit an offense or being assembled with intent to carry out some common purpose, conduct themselves in such a manner as to cause persons in the neighborhood reasonably to fear that the persons so assembled will commit a breach of the peace or will by such assembly needlessly and without any reasonable occasion provoke other persons to commit a breach of the peace, they are an unlawful assembly.
Absolutely. So the element that must be established is not just the act of coming together. You must go beyond that and establish that there is the intent to commit a crime.
Yeah.
Now, so that is understandable. But this definition, if you look at it closely, it suggests that the act of coming together, holding an assembly, in itself is what this bill seeks to prescribe. If that is the case, I would quickly run to the Constitution, Article 21, which grants us the freedom to associate.
Okay.
The freedom to associate. So like Honorable Banda has said, with this bill, we haven't dealt with the content yet. But if the time comes for us to delve into the content, we're going to raise all these issues that also border on constitutionality.
Okay.
Remember that Parliament cannot pass a law that runs counter to the Constitution. The Constitution is the superior law of the land. So these are matters that would come up for interrogation. Whether or not the definition proffered here does not even contradict the Article 21 on freedom of association.
Besides letting you go into the deeper part of it, do you think that his claim and the argument raising is substantive? Because let me just read that part and clearly say 21 starts with all persons shall have the right to a freedom of speech and expression. The specific part to do with the freedom of movement is actually there too. There is freedom of practice of any religion, the freedom of assembly, including the one take and processions and demonstrations, freedom of associations, which I include freedom to form or join any trade unions or other associations, national and international, for the protection of their interest. That's what he references as perhaps a blockade in the definition that's been proffered.
Those provisions are straightforward and clear and unambiguous. Persons have the right to form any association. So they have the right to come together and form an association with the intent of carrying out a lawful activity.
Yeah.
There is no ambiguity about it.
Yeah.
But it becomes an offense when you come together with the intent of committing an unlawful activity.
And you're able to determine the intent ahead of time?
Yeah, you have. I mean, you can.
Really?
You can. It's a matter of law. It's a matter of fact.
I see.
If 2 or 3 persons come together with the intent of committing an offense and they are arrested and taken to court, it rests on the prosecution to prove beyond all reasonable doubt that this is what the 2 or 3 persons intended to commit or have committed. And if you read the interpretation section of the bill very well, vigilantism means the act of enforcing law and order without authority. We know the enforcement of law lies within
a state authorities
the exclusive purview and jurisdiction of the states. I mean, enforcement agencies, except as provided in Article 3 of the Constitution. What is Article 3 of the Constitution saying? Article 3, so this bill is intended to accept activities that are captured under Article 3, which by the Constitution are deemed lawful. So, like I've already stated, I don't want us to go into the contents of the bill, because the bill itself will be subjected to public scrutiny
now,
and parliamentary scrutiny.
I want you to give us a broad view of what the various clauses within this bill seek to do. And you want to have an intervention?
Yes,
I'll go just briefly.
A quick one before I forget. You see, you made an important point, and I think it's instructive that we reference the Constitution. Article 106 actually requires that the explanatory memorandum to the bill must, amongst other matters, state the defects in existing legislation, if any.
Okay.
But you see, I've gone through this memorandum and I haven't seen any attempt to bring to the fore the defects in existing legislation, because it is acknowledged by all that there are existing legislation which can be invoked to deal with the issue of vigilantism. No defects have been identified in the bill itself. Like he said, we don't intend to deal with the substance of the bill, but these are matters that should engage our attention as we move on. I get
your point.
Yes.
Now, the Honorable, I want you to briefly run us through what really does this bill seek to do. What caught my eye is the part that you may be able to go, you may be incarcerated for 25 good years just by being identified or carrying out activity tagged as vigilantism. Isn't it?
Yeah, that is.
Okay, so tell us the other provisions in this particular bill, generally.
The provisions, if you start from the long title says that an act to disband political party vigilante groups, to prescribe acts of vigilantism in the country, and to provide for related matters. So the bill is dealing with, first of all, political party vigilante groups.
Okay.
It's also dealing with land, the issue relating to land guards. And then the application of the bill is to the effect that as soon as this bill becomes a law, all vigilante groups must be disbanded. All vigilante groups must be disbanded. And the law goes further to say that within a certain period after the passage of the law, leaders of vigilante groups must submit lists of the members of the vigilante groups, current members of the vigilante groups, and then former members of the vigilante groups. And the bill also tries to define people who aid and abet acts of vigilantism and vigilante groups.
Like the political party itself?
Yes, like section 4, clause 4.
I see.
Clause 4 of the bill, for instance, it says, a person shall not directly or indirectly instigate, command, counsel, procure, solicit, or in any other manner purposely aid, facilitate, encourage, or promote, whether by a personal act or presence or otherwise, or do an act for the purposes of aiding, facilitating, encouraging, or promoting the activities of political party vigilante groups. And then it goes on like that. It also includes persons who form vigilante groups, who fund vigilante groups, who organize vigilante groups. And there is one point that we must also take note of, that this bill must not be read in isolation. there are certain criminal activities that may be committed that will not be covered by this bill. So this bill is saying that it has to be read alongside with other existing laws or other existing legislation that deal with criminal activities. For instance, if in the course of vigilantism, as it is defined within the context of the law, somebody is killed as a result, this law is not dealing with murder.
Okay.
Because the sanction regime for murder goes far beyond 25-year imprisonment. So we have to have recourse to the Criminal and Other Offences Act that deals with the issue relating to homicide or the issue relating to murder. This bill, to the best of my knowledge, for instance, does not deal with causing harm. Causing harm. All that it is purpose to deal with is to deal with the issue relating to vigilantism. But if as a result somebody is maimed or grievous bodily harm is occasioned on the body of a person, there is a relevant law that can deal with same.
I see.
So what I'm saying in a nutshell is that this bill, it is good that it is coming. It is not out of place. Yes, I do admit that there are a lot of laws that can probably deal with the issue of vigilantism. But to the extent that vigilantism is now becoming something that seems to be getting out of control, there is a clarion call by all and sundry, by religious bodies, by the Peace Council, by political parties to deal with the issue of vigilantism. This bill is a step in the right direction to deal with it. When MPP and NDC met, I'm told that NDC and MPP have issued a communique to the effect that vigilante groups must be disbanded. And when the president appeared before Parliament, when he came to deliver his message on the state of the nation, he did say that he will meet all political parties to find a lasting solution to the issue of vigilantism. And he went further to say that even if it will need, there will be the necessity for a legal regime to be brought into place to deal with the issue of vigilantism, he is prepared to do so. I think that pursuant to the promise of the president, that is why this vigilantism and related offences bill has found its way in Parliament. So let's not preempt the views of civil society organizations, religious bodies that may be brought to bear on the vigilantism and the related offences bill that is now currently before Parliament. It is on the basis of this, like issues that he has raised, that we have other laws. Yes, other issues that people have raised concerning the issue of vigilantism. It is on the basis of this that in the wisdom of the committee, we think that yes, let's all meet and brainstorm and listen to views and ideas. If at the end of the day, people or majority of Ghanaians are of the view that yes, the issue is not about law at all. The issue is about having the political will and the political determination to deal with the issue of vigilantism, and therefore this bill is of no moment, is of no use, then it is the people of Ghana who have spoken. But I think that once we haven't gotten to the bridge yet, let's exercise a little bit of patience and restraint and await the views of the generality of the public. So because of whose
the legislature has been described sometimes as a rubber stamp, especially those of you who happen to be in the majority, whether during the NDC or the MPP's time. You hardly oppose your own bills coming from the government or the presidency or any of the ministries in this case. The hope you are giving us that when majority of Ghanaians rejected this are reflecting the decision of the legislature, is it really realistic?
Realistic in what sense?
I'm saying that the hope you are giving us, that if Ghanaians say that no, the problem has very little to do with laws, would it really reflect in the decision of your committee?
Yeah, we have to listen to the people.
Really?
Yeah, we have to listen to the people.
Even if the executive president wants the bill passed?
If the executive wants the bill passed, and the majority of people for whose interests those of us in political offices are serving say that we don't want the bill. The issue is not about a bill at all, a law at all. The issue is about the executive, taking the bull, by the horn,
okay, and
dealing with the issue of vigilantism frontally. Why not? We'll listen to the public. But let me say this. Political will and political determination to deal with an issue doesn't lie with the government alone. You and I have a great responsibility to ensure that all laws that have been passed are implemented. You and I and the executive have a responsibility to ensure that the police or the law enforcement agencies that are mandated within the context of the law to ensure the implementation of the law are well and adequately resourced to be able to, ensure that the law is well implemented.
But to be fair, we've not been able to ensure that the current laws are implemented. We should add up more laws.
No, what I'm saying is that if you leave the implementation to the power that be,
to the people who are paid to do it,
to the
that's
power
the
that
most
be,
important thing.
To the power that be.
I see.
There may be a time that you have a president who may not be interested in ensuring that a law is implemented.
I see.
We have a responsibility as citizens. That, to me, is we have a responsibility as a citizens to ensure that a law that has been passed is implemented.
Okay.
Now, the right to information law has been passed. It's yet to be assented to. Who ensures that it is implemented? It is the executive. It is people who find themselves in political offices.
Yeah.
What is it that we have to do? We have to provide the necessary resources to ensure that the right to information law is implemented.
Okay.
Okay. But whose duty is it to ensure that those of us who find ourselves in political offices are accountable and responsible enough for what we say
put together.
We should be doing.
Now, I'll come to you, Honorable Gaga. I get the impression, and you were the one who raised the first concern about many laws, implementation is always a problem in this country. So bringing another one might not be the solution in this particular case. After the explanations he has given, have you changed or you attempted to change your original stance on whether or not this law by hook or crook is needed?
Look, Raymond, I think that I have established sufficient ground to buttress the point I made.
And that's not changing even in the face of the contrary disposition he just did.
No. There are two sides to a coin.
I see.
And so remember that if the two of us were before a judge,
yeah,
I mean, he would canvass cogent reasons why
his side
at the end of the day, his side of the story must prevail. I have my counter arguments, and I've made those arguments known and very forcefully.
Yeah.
Look, having said that, I made the point earlier on that if legislation is the path we all need to walk, there is every reason why we should follow a certain roadmap that the president himself put out there for all of us to follow.
What happened?
Remember that it was the same president who, in the aftermath of Ayawaso, told us, first of all, he set up the commission of inquiry and tasked them to come out with a report within 1 month. Yeah. The commission didn't falter within the stipulated time frame. They were able to submit their report. The president is seized with the report. Then, when the president came to deliver the State of the Nation address before Parliament, he invited the two major political parties, the MPP and the NDC,
yes,
to dialogue over the issue and voluntarily disband. I insist that as we speak, the political parties are still meeting. They have not come out with a communique to state whether or not they are willing to voluntarily disband or not. Now, whilst the meeting is going on, whilst the commission's report hasn't even been made public, at least for the consumption of Parliament and the general public, the President immediately triggers the process of passing legislation, contrary to his own conditional statement. And let me refer you to the last but one paragraph on page 1 of the memorandum, and it reads as follows. Let me start. While the Commission of Inquiry was still sitting, the President, during his message on the state of the nation, delivered on 21st February 2019, encouraged the leadership of the main two political parties, namely the MPP and the NDC, to come together to bring an end to this phenomenon of political party vigilantism. The President also stressed that if voluntary disbandment by the two main political parties was not feasible, then he would initiate legislation. If that was conditional.
Was not feasible.
Was not feasible. The political parties have not concluded with their negotiations. Why the haste to introduce this particular bill at this point in time? Is it to score some political point?
Is
that the case?
No.
Because it appears there is some indecent haste on the part of the government. That is my worry. And that is why I would always refer you back to the point I made earlier, Ron, that there is no need to hasten over matters like this, because as we speak now, there are some existing legislation
I get you
that can be invoked to deal with the matter for the time being.
No problem. But the two are not mutually exclusive.
Okay, yeah.
The two are not mutually
But it sounded that they were from the tone of the statement.
Saying that NDC, in principle, doesn't agree that their vigilante groups should be disbanded.
But that's not the question,
yes.
Is it? Yeah.
So if that is what he's saying, and he agrees in principle that vigilantism, political vigilantism is bad, and for that matter, political vigilante groups must be disbanded, then the bringing of this bill to Parliament is a step in the right direction. In any case, this bill will not be passed today. It won't be passed tomorrow. Parliament is rising tomorrow.
Okay.
And he himself is aware that pursuant to the recommendation we presented to the plenary, we are to do a stakeholder engagement.
Who are the stakeholders in this case?
Stakeholder engagement means that we have to bring on board all political parties.
I see.
So NDC will be brought on board, MPP will be brought on board, other political parties will also be brought on board. Security experts will be brought on board. They have to present their perspective and views to us
on this law
as to whether a bill or a law to deal with vigilantism is the best way to go. Even if parties agree that vigilantism is bad and therefore vigilante groups must be disbanded, we cannot just say it and act on it without supporting it and grounding it in law.
I see.
Nana Akufo-Addo may be a very good president. He's a very good president. For that matter, today you say political parties disbanded. Tomorrow, another president may come who may not necessarily be interested in disbanding or dealing with the issue of vigilantism.
Okay.
But if we have a law in place, a legal regime in place, accepted by all and sundry, accepted by all political parties, whether we have a president who has the political will and determination to deal with vigilantism or not, to the extent that everybody has bought into that law, the law will work. So the two
and this is to
are
presume
not
that
mutually exclusive.
Whichever president that would not like the law, the Attorney General would independently decide to prosecute people because the president, contrary to what the president likes or not, we all know that the Attorney Generals work for presidents.
No, what I'm saying is that we have the political will. The political will is personal.
Okay.
To the person who holds the executive power is personal.
I'm concluding this discussion because my time is up. Now, let me get this from you. When is this law going to be passed? When?
Now, Parliament is rising tomorrow. All things being equal, we are being recalled to Parliament on the 29th of this month.
Okay.
All things being equal. And during the recess, the short period, we'll have to convene and then do the I mean, if I say we, I mean the committee will have to convene, do stakeholder engagement, solicit views in order to be able to present the report to Parliament on the 29th of this month, which would then...
Can you pass it the same day?
We are coming on the 29th.
Can you pass it the same day?
No. Passage of the bill doesn't lie within my remit. So I cannot say that.
Raymond,
but we are coming back purposely.
My time is up. Final word for me, 10 seconds.
Yes, we may have to do some amendments. I think the bill is inadequate.
One,
in the sense that it doesn't address the issue of vigilantes who masquerade as state security agents. We saw that at Ayawaso.
All right, I get your point. And I guess we
saw that at Ayawaso.
We can leave it up here.
Deal with everything.
The chairman of the Committee on the Parliamentary, Legal and Constitutional Affairs, the ranking member on the Defense and Interior Committees were my guests on Upfront today. Many thanks to you for joining us on today's edition.